are not quite ready to get started yet. I'm waiting for one more set. Actually, we're ready to go. Thank you for your patience, everyone. Your presiding judge today is going to be the Honorable Judge Angie Arkin. If everybody is ready to go. Not quite ready to get started yet. I'm waiting for one more set. Actually, we're ready to go. Thank you for your patience, everyone. Your presiding judge today is going to be the Honorable Judge Angie Arkin. If everybody is ready to go.
Veronica, you have an echo. Not sure what that's about. You are now muted. Were you able to unmute yourself? You show as muted on my screen. Okay, so she's logging out and logging back in. Nobody panic, please. Happens all the time in the virtual trial world, trust me. Happened yesterday, happened Monday. So every day in the life of a judge these days. So everybody chill. Okay, so I have a chat that says I need to just go ahead and get started. So is everybody who is participating present? You can just nod. Everybody? Okay. So counsel who are starting, are you ready to proceed? Please unmute yourself and respond.
Your Honor, the prosecution has some preliminary matters that they wish to discuss.
So first I need to know if you're ready, but yes, I'm happy to hear preliminary issues. Who's here for the defense?
Your Honor, I am here to represent the defense in preliminary matters.
Okay, so have the scoring panelists all been provided with a trial roster to your knowledge?
Your Honor, I don't believe that any of our scoring panelists have received rosters at this point. So perhaps if the teams could introduce themselves so our scoring panelists can know their positions.
Okay, so let's get started that way, please. Let's introduce the teams before we address any further trial matters. So who is representing the people? Okay, so Mr., and if I mispronounce it, please forgive me, Rutson?
Yes, Your Honor.
You want to start, sir?
Yes, Your Honor. Good afternoon, Your Honor. My name is Aiden Routson. I am for the prosecution. Today, I will be delivering the direct examination of investigator Kyle Kuzak and the cross-examination of the defendant Avery Becker, as well as delivering the closing argument. May my co-counsel please be permitted to introduce themselves?
Yeah. Go ahead.
Good afternoon, Your Honor. My name is Nina Lawson for the prosecution, and today I'll be conducting the direct examination of Jordan Markowitz and the cross-examination of Blake Van Owen.
All right, who's next?
Good afternoon, Your Honor. My name is Annie Entner. I will direct Alex Cifuentes and cross Taylor Perkins and deliver the opening statement.
All right.
Your Honor.
Any other team members?
Yes, Your Honor. May our witnesses please be permitted to introduce themselves?
Yes, sir. Thank you.
Good afternoon, Your Honor. My name is Emily Rosenberg, and I am Detective Jordan Markowitz.
Thank you.
Good afternoon, Your Honor. My name is Logan Piscadlo, and I am Kyle Kuzak.
Thank you, ma'am.
Good afternoon, Your Honor. My name is Abby Sears, and I'm Alex Cifuentes.
Thank you. Okay, I'm assuming that's the prosecution team. Who is first for the defense, please?
Good afternoon, Your Honor. My name is Monsi Gouda, and I will be performing the opening statement as well as the direct for Avery Becker and the cross-examination of Detective Markowitz. At this time, I request permission from my co-counsel to introduce themselves.
Go ahead, Ms. Gouda. Oh, who's next?
Good afternoon, Your Honor. Opposing counsel and members of the jury. My name is Braden Tours, and today I will be performing the direct examination for Taylor Perkins and the cross-examination for Alex Cifuentes.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Katie O'Connell, and I'll be performing the direct for Professor Blake Van Owen, the cross for Kyle Kuzak, and the closing for the defense. I would now like to ask for permission for our witnesses to introduce themselves.
So permitted.
Hello, Your Honor. My name is Isabella Heidman, and I am Professor Blake Van Owen.
All right.
Good afternoon, Your Honor, and members of the jury. My name is Rowan Brady, and I am Taylor Perkins.
Okay.
Good afternoon, Your Honor, members of the jury. My name is Chloe Conklin, and I'm Avery Becker.
All right. Is that everyone? You can just nod your heads if that's okay. So is anybody videoing this presentation to the knowledge of anyone who's present? Okay, I'm seeing an indication that everybody's shaking their head no. Anyone who's in the gallery who's not connected with the teams competing should not be present. Okay. No recesses will be allowed with the exception of those granted for a health emergency, and certainly not between the examination of a witness and the cross-examination or redirect. Okay. Let's see. Let's see. Each scoring panelist. Well, there's been a conflict check for the scoring panelists already, so we don't need to talk about that. Disputes arising out of this competition must be reported in accordance with the competition rules, and they must be reported immediately. Compliance with time requirements will be considered in scoring individual performances. No coach or team member other than a timekeeper should be seated, well, in the jury box. Each side, okay, so you've introduced everyone. All right, so if you could raise your right hands for me, please. And this is, I seem to be missing. Okay, thank you. Everybody seems to be present. Now we are. Okay. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? Okay. Witnesses, do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition? Witnesses? All right. And scoring panelists. Well, actually, I don't know if there are gallery members out there. Are there gallery members out there?
There are not, Your Honor.
Thank you, ma'am. Scoring panelists. So you all, please, you're welcome to put your arms down. Can I see the scoring panelists, please? Thank you. Can you raise your right hand for me, please? Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition? Okay, I got an affirmative. So now everybody who is not going to be discussing with me, please, the preliminary matters, please mute yourself and turn off your screen. Gentlemen, I think, sorry, with a mask, I'm not sure, but I'm guessing, and I apologize if I in any way, okay. All right, are you okay not having your mask on, sir? You don't have to take it off.
Yes, Your Honor, we are adequately distanced, so while we are speaking, we may take our masks off.
Okay, I didn't want to instruct you in that regard. Okay, so Mr. Rootson, is that better?
Closer, Your Honor.
Pronounce it closer. Can you pronounce it for me, sir, please?
It's Routson.
Routson. Yeah, still murdered it, sorry. You were going to go first and address the preliminary matters, sir?
Yes, Your Honor. The prosecution moves preliminarily for the stipulations to be entered into evidence.
Any objection, Mr. Tours?
No, Your Honor.
And is that a correct pronunciation, sir?
Yes, Your Honor.
Thank you. Go ahead, Mr. Rootson.
The prosecution would also like to request permission to constructively publish the exhibits to the jury after admission.
That would be the court's expectation. I'm not guessing there's any objection to that. Okay. Go ahead, counsel.
And then finally, I would request that any time remaining after the initial closing statement be reserved for a rebuttal close.
All right.
No objections, Your
Honor. All right. Mr. Rootson, you may proceed.
Thank you, Your Honor. No further preliminary matters at this time.
All right. Who's doing your opening statement, sir?
That would be...
I am, Your Honor.
Okay, Ms. Entner.
Thank you. May it please the court, Your Honor, members of the jury. My name is Annie Entner, and I represent the state in the case against defendant Avery Becker. Members of the jury, this is a case about one thing: bad decisions. Nobody has to be a bad person to make bad decisions, and today you will hear how the defendant made one bad decision after another, which led to her murdering her mock trial coach, Mackenzie Brackman. Today, you will hear evidence that proves the defendant is guilty in 3 ways. First, the evidence points to the defendant. Second, the crime scene and other evidence was analyzed by 2 expert witnesses. Third, the defendant had a strong motive. The defendant was a student at Colorado High School and knew Mr. Brackman because he was her mock trial coach. The 2 often argued because Mr. Brackman thought that the defendant did not put in the work that she should. Eventually, the defendant was demoted to B team, and after the situation escalated further, Mr. Brackman kicked her off the team. The night that the defendant was publicly kicked off the team and humiliated, she stormed into the school parking lot and wrote on Mr. Brackman's car in permanent marker. And this destruction of property was only the beginning. On March 6, 2020, Mackenzie Brackman was found dead in his home just a few days after the defendant threatened to trash his house. For the defendant, one bad decision led to another. Arguing led to anger and frustration. Anger and frustration led to vandalism. Vandalism led to threats, and threats led to murder. A murder that brings us here today. A murder where the evidence clearly proves that the defendant killed Mr. Brackman. First, the evidence points to the defendant. Today, you will hear how the police collected and analyzed the cell phone tower data showing that the defendant's phone went from her house to Mr. Brackman's house the day of the murder. Second, you will hear how two expert witnesses analyzed and collected evidence at the crime scene and outside of the crime scene and came to the conclusion that the defendant killed Mr. Brackman. At the crime scene, the two analyzed the knives, which was the weapon used during the murder, broken plate on the floor, and blood splatter. Outside of the crime scene, both of them collected and analyzed the cell tower details and call detail records for the defendant's phone. Third, you will hear how the defendant had a strong motive. You will hear from one of the defendant's friends and teammates give an account of how the defendant was proud and angry and made one bad decision after another, which led to her murdering her mock trial coach. On March 6, 2020, Mackenzie Brackman was murdered in his home by the hand of a student, Avery Becker. The evidence today will show that it is clear the defendant killed Brackman because of her anger and pride. Members of the jury, at the end of the trial today, we will ask you to vote in favor of the state by finding defendant Avery Becker guilty of murder in the first degree and guilty of attempting to commit second-degree burglary because of her bad choices.
Thank you, ma'am. Did the defense wish to make an opening statement?
Yes, Your Honor. Good afternoon, members of the jury. My name is Monsi Gauda, and I, along with my colleagues Braden Tours and Katie O'Connell, have the privilege of representing the defendant, Ms. Avery Becker, in today's trial. There is no simple way to put this. An innocent man was murdered, and an innocent woman is blamed for it. We cannot let justice fail once more, and so the defense asks you to listen to and take into account what truly happened. On March 6, 2020, a well-known and respected lawyer and mock trial coach, Mackenzie Brackman, was murdered. His house was broken into, and within that chaos, Mr. Brackman was killed. Bringing justice to Brackman's death is of paramount importance and can be accomplished by doing one thing: finding the true heinous killer of Brackman, not by blaming Miss Becker for a crime she never committed. A blameless, innocent teenager being pinned and blamed for breaking and entering, and more gravely, murder. Members of the jury, this is a case of mistaken identity, and at the end of the trial today, the defense strives to obtain justice for not just one, but two individuals, Mackenzie Brackman and Avery Becker. You've already heard from the prosecution, and what they aspire, or hope, or anticipate to prove is that Miss Becker was in fact Brackman's murderer. However, they failed to do one very crucial thing: tell the full story. The prosecution will not show you Alex Cifuentes' full phone records. They will not show you Taylor Perkins' phone records. They will try and bring forth corrupted photos that no one has seen as evidence. They will fail to bring up that another student had the opportunity and motive to commit this horrible crime. In the end, all the prosecution will show is speculation, conjecture, and reasonable doubt. However, the defense brings full evidence, substantial evidence, that will prove that Avery Becker was set up to take the fall for Brackman's murder. Bringing forth true hard proof of Miss Becker's innocence, the members of the jury will hear from three witnesses today. You will hear from Blake Van Owen, Taylor Perkins, and Avery Becker. The first witness will be Blake Van Owen. Van Owen is a private investigator, a professor, and an expert witness in police practices. Van Owen comes here today with years of experience to testify as an expert witness. He has been accepted by various courts as an expert in crime scene and reconstruction 8 times, in cell tower analysis 5 times, and in general police investigation tactics 12 times, and has consulted on more than 100 cases. Van Owen will lead the members of the jury through the case and show how faulty the prosecution's argument is through displaying how many things they failed to bring up. He will show what the police missed, and more importantly, what Detective Markowitz missed. He will testify with an expert report to show there was no possible way Avery Becker killed Brackman. The next witness the defense will call is mock trial participant and true friend to Avery Becker, Taylor Perkins. Perkins spent most of her time doing work for mock trial or hanging out with Miss Becker. Perkins will testify today and prove that Becker was with her around the time of the murder. She will prove that there was another student that could have murdered Brackman. She will prove that Alex Cifuentes and Avery Becker were never friends, despite what the prosecution will try and claim. Finally, Perkins will testify and prove Becker's innocence by showing Becker did not have her phone, an extremely important piece of evidence. The final witness the defense will call is Avery Becker. Becker will testify today and prove her innocence. She will further back up Perkins' statement and show there was another student that could have murdered Brackman. She will prove to the members of the jury that she did not have her phone around the time of the murder. Avery Becker is here today to prove she had absolutely no hand in what resulted in Mackenzie Brackman's gruesome death. The defense will exculpate Avery Becker, who stands here today wrongly accused of the crimes of first-degree murder and second-degree burglary. And at the end of the trial today, we ask that you, members of the jury, see through the prosecution's false claims against Miss Becker and bring true justice upon Mackenzie Brackman's death by doing what is simply right, finding the defendant, Avery Becker, innocent of these charges. Thank you.
All right. Will the people call your first witness, please?
Your Honor, the prosecution calls Detective Jordan Markowitz to the stand.
All right. Ms. Markowitz, I'll remind you, you are under oath. You may proceed, Ms. Lawson.
Thank you, Your Honor. Will you please state your name for the court?
My name is Detective Jordan Markowitz.
Can you talk about your job experience?
Yes, I've worked with the Denver Police Department for around 13 years now, and I've spent 7 of those years as a homicide detective.
Do you hold any special certifications?
Yes, I hold certifications for forensic data recovery and cell phone technology.
And can you talk about the training that you had to complete in order to obtain this cell phone technology and forensic data recovery certification?
Yes, I had to go through an in-depth training course with the American Academy of Law Enforcement and pass the certification test.
And what does this certification entail?
I'm proficient in analyzing cell phone data and using forensic software such as the Celebrite system to obtain cell phone data and interpret cell tower data.
And how often have you used this training in your professional experience?
I've used it in over 50 cases, and I continue to use it on a regular basis.
Your Honor, at this time, I would like to submit for the approval of Jordan Markowitz as an expert in the field of cell phone technology and forensic data recovery pursuant to Rule 702.
Voir dire?
Yes, Your Honor. All right, Ms. Markowitz, can you confirm that you only had to pass a 3-day training course and a certification test in order to become certified in the areas of cell phone technology and forensic data recovery?
Yes, that's correct.
Have you ever attended and completed formal education for forensic data recovery?
Yes.
Have you ever attended and completed formal education for cell phone technology?
Yes.
Your Honor, at this time, I tender this witness as an expert as a homicide detective, but not in cell phone technology and forensic data recovery.
Overruled, the witness can testify as an expert on cell phone technology and forensic data recovery, as well as a detective. You may proceed, Ms. Lawson.
Thank you, Your Honor. Can you describe when you were called to investigate this case?
Yes, I was first called to investigate this case on March 6, 2020, after a motorist saw an unconscious person outside of Mackenzie Brackman's home.
Can you describe what you observed when you first arrived on the scene?
Yes, when I first arrived at the scene, I saw the victim was face down in a pool of blood. The front door was wide open, and I also noticed a Ring doorbell next to the front door. I decided to investigate this further, and I ultimately showed the intruder.
What did you find when you looked at Mackenzie Brackman's Ring account?
I discovered that he had been paying an extra monthly fee to keep all recordings of the videos created on the doorbell.
Were you able to access any other data from Mr. Brackman's phone?
Yes, I was able to access his photos, text messages, and the data stored on his apps.
Can you describe what you saw while looking through the data on his phone?
Yes, I noticed that he'd been getting lots of text messages from a group chat called Mock Trial. I decided to do some further research and I discovered that he was a mock trial coach at CHS.
What did you do after discovering that Mr. Brackman was a mock trial coach?
I immediately contacted the school and got all of the contact information for every student on the mock trial team. I started with by calling Alex Cifuentes.
What did you learn after speaking with Alex Cifuentes?
I learned that a student named Avery Becker had recently been kicked off of the mock trial team for vandalizing Mackenzie Brackman's car. I also learned that Alex Cifuentes had recently gotten a text from Avery Becker stating that Becker was planning to trash Brackman's house.
What did you do next after conducting the interview with Alex?
I obtained her cell phone number so I could get a court order to obtain the cell phone account records and the cell detail records from her phone.
What are cell detail records?
Cell detail records is when you place a call or text, a record of the event is created. It shows the time and date of the event, and it shows whether it was incoming or outgoing, the number of the other phone involved, and the location of the cell towers communicating through.
Do you have access to exhibits 15 and 16?
Yes.
Does the opposing counsel in court have access to what has been previously marked as exhibits 15 and 16?
Yes.
Yes.
Detective Markowitz, do you recognize these exhibits?
Yes.
What are these exhibits?
These are diagrams showing the call records for March 6, 2020.
And who created these diagrams?
These are my diagrams that depict the defendant's phone communication and location from the time of the murder.
Do these diagrams assist you in forming your expert opinion regarding this case?
Yes.
And have these maps been altered in any way?
No.
Your Honor, at this time, I move for the admission of exhibits 15 and 16 as evidence.
Ms. Gouda? Gouda? I'm sorry. Yes, ma'am. I can't see your name, and so I apologize. I couldn't find it on my little sheet here. Can you show your video, please, ma'am?
Oh, I had it turned on and I was told to turn it off, but yes, Your Honor.
Yes. So, counsel, just for everybody who's out there, when you are the opposing counsel, when both sides are present, the four of us should be on video. So Ms. Gouda, going forward, you can stay on video, and that way you can just unmute when it's your turn to respond. So go ahead, Ms. Gouda. Did you have a response?
No, Your Honor.
All right. 15 and 16 are admitted. Go ahead, Ms. Lawson.
Your Honor, permission to screen share exhibit 15?
You may.
Can you see the exhibit?
Yes, ma'am.
Can you describe what this exhibit shows?
This is a cell detail record, and it shows which cell towers the communications from Becker's phone were going through on March 6, 2020.
Your Honor, permission to screen share exhibit 16?
You may.
Can you describe what this exhibit shows?
This is the same diagram as exhibit 15, except it has the most probable route in which Becker had taken to get to Brackman's house.
What do these records indicate?
These records indicate that Taylor Perkins had been trying to contact Avery Becker before and after the murder. The first communication came from a cell tower covering Becker's house. The next communication came through Rock Creek Parkway, and the last and final communications came through the cell tower covering Brackman's house.
In your expert opinion, what conclusions did you come to after looking at these records?
After looking at these records, we came to the conclusion that Avery Becker's cell phone was at Mackenzie Brackman's house during the time of the murder.
What did you do after forming this conclusion?
We made Avery Becker our prime suspect, as she seemed to be had the most probable cause, and we charged her with first-degree murder and second-degree burglary, and also arrested her.
Thank you. No further questions, Your Honor.
Cross-examination.
All right, Ms. Markowitz, before we get started, could you please refer to lines 6 and 7 of your affidavit and read them out loud?
Yes. I'm sorry, I'm having a hard time finding it. Would you mind sharing it?
I have it printed out. Would you be okay with me reading it to you?
Yes.
Okay. To get it, I had to complete a 3-day training course and pass the certification test. All right, so Ms. Markowitz, can you then confirm that you have not, in fact, attended and completed formal education for forensic data recovery and cell phone technology?
Yes.
All right, thank you, Ms. Markowitz. Were you the first person to arrive at the scene of the crime?
Yes.
Upon arrival, you immediately noticed the Ring doorbell, correct?
That's correct.
You also noticed the blood splatter marks, yes or no?
Yes.
All right, Ms. Markowitz, could you refer to lines 16 and 17 of your affidavit? Would you like me to read them out loud for you?
Yes, please.
Paramedics initially responded but called for officers upon finding the victim, Brackman, deceased just inside the front door of the residence. So, Ms. Markowitz, this would confirm that you were not, in fact, the first person at the scene of the crime, correct?
Yes. Correct.
All right. So then you then stated that at the scene of the crime, those photographs taken of those blood drops had been corrupted, correct?
Correct.
You also mentioned that the blood splatter picture was never recovered, correct?
Correct.
So then, without conducting a detailed analysis, you assume that this blood splatter was a cast-off mark, yes or no?
Yes.
While working with the DPD, you investigated homicides that Brackman would later defend, correct?
Correct.
You expressed that you had the displeasure of being cross-examined by Brackman for the cases you investigated. Is that true?
Yes.
It's safe to say that you didn't always get along with Brackman due to the cheap shots, as you stated, Brackman would take at the DPD, correct?
Correct.
You also believe that Brackman's death could be the result of a disgruntled ex-client, correct?
That's correct.
Okay, Ms. Markowitz, I'd like to turn your attention to the CHS mock trial team now. Did you talk to any of Brackman's students from the CHS mock trial team?
Yes, Alex Fuentes.
When you asked the Fuentes to look at their phone, they had not brought it to their interview, correct?
Yes, that's correct. But I understand that teenagers can be very forgetful.
Let the record reflect that it is expected that the witness is looking at a clean and unmarked copy of what has been previously marked as exhibit number 14. Do you have the exhibit printed with you, or would you like me to screen share?
I have it with me.
All right. Please refer to this exhibit. However, the next day, Cifuentes sent you these screenshots of this conversation. Isn't that right?
Yes.
Meaning you never had the benefit of seeing these text messages for yourself, correct?
No, but I believe that these would be good enough.
All right, Ms. Becker, or Ms. Markowitz, how hard would it be to program the name Avery Becker as a contact on someone's phone?
Pretty easy, but I do not believe that Alex Fuentes would have done this.
Did you ever check the reliability of these texts that Cifuentes had emailed you?
No.
Was Cifuentes the first student you talked to?
Yes.
Was Cifuentes the only student you talked to?
Yes.
So it would be safe to say that Cifuentes guided the direction of your investigation.
Objection, argumentative.
We'll move on, Your Honor.
All right.
Okay, I'm going to turn your attention to the ring videos now. You believe that Becker was the person in the ring videos taken at the scene of the crime. Is that right?
Yes, that's correct.
Could you see any specific features in the person of the ring video that would have confirmed that it was Becker?
No, but my cell detail records from the date of March 6, 2020 show good evidence in which it could have very well been Avery Becker.
All right. When you obtained data from Brackman's ring account, did you ever find out if Brackman had notifications on to notify him if there was an intruder?
I did not.
Okay, I would like to direct your attention to the call towers now. You stated that it's not always true that a cell phone would connect to the nearest tower. Is that correct?
That's correct.
The cell phone might also just connect to the best available tower, which isn't always the nearest tower, yes or no?
Yes.
Meaning that the cell towers are not 100% reliable, correct?
Correct.
However, the most logical path that you believe Becker could have taken to Brackman's house was Rock Creek Parkway, correct?
Yes, that's correct.
More specifically, after crossing Colton Road to join Rock Creek Circle, Becker could have reached Brackman's house, correct?
Correct.
The communications that came through Becker's phone on March 6, 2020 went in the order of 1227-3, 1191-1, and then 1197-1 in terms of cell towers. Is that true?
Yes.
Do you have a copy of exhibit number 16 available to you?
Yes.
Do you recognize this piece of evidence?
Yes.
So you would agree that the pathway I had previously stated would have solidified the idea that that was the route that Becker would have taken, correct?
Correct.
Blair Rowlands lives by Becker and under the same call tower, correct?
Correct.
In your expert opinion, how hard would it be for Blair Rowlands to take the exact same path that Becker might have?
Can you please repeat the question?
In your expert opinion, how hard would it be for Blair Rowlands to take the exact same path that Becker might have?
Objection, lack of foundation or knowledge.
For lack of knowledge, Your Honor, I just for lack of foundation, Your Honor, I just asked a bunch of questions that would have set a good foundation up for this question to be asked.
The objection's overruled. The witness shall answer.
All right, so I'll repeat the question for you, Ms. Markowitz. In your expert opinion, how hard would it be for Blair Rowlands to take the exact same path that Becker might have?
It wouldn't have been too difficult, but it was Becker's phone that did take that path.
All right, under that call tower, 1197-1, there were 3 incoming phone calls that were so short that it seemed like there was no real connection, correct?
Correct.
That would mean there were 3 incoming phone calls that the person with Becker's phone in their possession did not pick up. Is that right?
Yes.
So then you made the assumption that the defendant, Ms. Becker, had been too busy committing a crime at Brackman's house to respond to Perkins. Is that true?
Yes.
While your deposition was taken, you swore that you would follow the evidence and go wherever it takes you. Yes or no?
Yes.
All right, Ms. Markowitz, that'll be all. No further questions, Your Honor.
All right. Any redirect? Ms.
No,
Lawson? All right. The witness can step down. Thank you, ma'am. The people, call your next witness, please.
Thank you, Your Honor. The prosecution calls investigator Kyle Kuzak to the stand.
Ms. Kuzak, I'll just remind you you're still under oath. Whenever you're ready, counsel.
Thank you, Your Honor. Investigator Kuzak, please state your name and spell your last for the court.
Kyle Kuzak, Kuzak.
What is your current occupation?
I am a certified crime scene reconstruction investigator at the Colorado Bureau of Investigation.
Can you describe what experience you have had while doing this job?
Yes, I have 19 years of experience of investigating complex crime scenes such as home invasions, armed robberies, fatal accidents, and more.
And what are your responsibilities as a crime scene reconstruction investigator?
First, I assume every case is going to trial. Then I start from day one with documenting, organizing, and memorizing all the evidence with mindset of future reconstruction.
Are there any specific processes that you've become prone to using throughout your 19 years of experience investigating these complex crime scenes?
Yes.
And what are they?
I follow the Tom Bevel and Ross Gardner 7-step methodology, which includes making flowcharts and worksheets to apply to scientific methods to difficult sequences. This process creates more investigative questions, therefore creating a more comprehensive analysis of this case.
And do these help you to gain a better understanding of the case?
Yes.
Your Honor, pursuant to Rule 702 of the Federal Rules of Evidence, at this time, the prosecution moves to have investigator Kyle Kuzak admitted as an expert in the field of crime scene reconstruction.
Voir dire?
Not at this time, Your Honor.
All right. So admitted.
Thank you, Your Honor. Investigator Kuzak, do you have an accurate understanding of the facts of this case?
Yes, I visited the homicide at 444 South Flower Street after it was investigated by other members of the crime lab. I also investigated all of the police reports of this case, the photographs, and the 4 Ring security camera videos.
Did you examine all evidence in this case?
Yes.
And do you have access to exhibits 10, 11, and 12?
Yes, I do.
Does the opposing counsel and the court have access to what have been previously marked as exhibits 10, 11, and 12?
Yes.
Uh-huh.
Investigator Kuzak, do you recognize these exhibits?
Yes.
Have you reviewed these exhibits prior to the court proceedings today?
Yes.
Without going into detail of what these exhibits show, can you please describe what these exhibits are?
These are security camera videos taken from the Ring security camera system from the Brackman's residence.
Did these exhibits help you in forming an expert opinion in this case?
Yes, they did.
And have they been altered in any way, shape, or form?
No, they have not.
Your Honor, at this time, the prosecution moves to have exhibits 10, 11, and 12 entered into evidence.
Any objection?
No objection, Your Honor.
10, 11, and 12 are admitted. Go ahead, counsel.
Thank you, Your Honor. At this time, may I please have permission to screen share exhibit 10?
You may.
And can everyone see this exhibit?
Yep.
Yes.
Investigator Kuzak, can you please describe what you see in this exhibit?
A perpetrator wearing mask and gloves approaching the Brackman's residence. They appear to look into the front door, then proceed down south of the residence.
Your Honor, may I have permission to screen share exhibit 11?
You may.
Can everyone see exhibit 11?
Yes, sir.
Yes.
My apologies, it seems that the video cut out. May I have permission to play it again?
Yep.
Investigator Kuzak, can you please describe what you observed from this exhibit?
Yes, the same perpetrator from exhibits 10 continues down south of the residence, opens the back gate, and enters the backyard.
Your Honor, permission to screen share exhibit 12.
You may.
And can everyone see this exhibit?
Yep.
Yes.
Investigator Kuzak, can you please describe what you observed from exhibit 12?
The same perpetrator from exhibits 10 and 11, opening the back glass sliding door of the Brackman's residence and going into the residence. As you can tell, that the glass sliding door makes a considerable amount of noise.
What expert opinions did these exhibits help you to form?
These videos were a very crucial part of the process of reconstructing this crime scene. They helped me create two conclusions. The first being that the perpetrator in these videos are the same, like matching the general height and build of the defendant. And the second, with the most compelling evidence pulled through, is that the perpetrator in these videos had prior knowledge to the Brackman's residence. These videos assisted greatly in reconstructing this crime scene. They helped me understand how the perpetrator entered the Brackman's residence and how easily they made it to the back entrance.
Investigator Cusack, do you have access to a copy of Exhibit 8?
Yes, I do.
Does the court and opposing counsel have access to this exhibit?
Yes.
Yep.
Investigator Cusack, will you please reference this photo?
Yes.
Do you recognize this photo?
Yes.
Without going into detail of what this exhibit shows, can you please describe what this exhibit is?
It is a knife block taken, a picture of, sorry, let me rephrase. It is a picture taken of the knife block from the Brackman's residence.
And did this photo assist you in forming an expert opinion in this case?
Yes.
Your Honor, at this time, I move for the admission of Exhibit 8 into evidence.
Any objection?
No objection, Your Honor.
All right, 8's admitted.
Your Honor, at this time, may I screen share Exhibit 8?
You may.
Can everyone see the exhibit?
Yes, sir.
Yes.
Investigator Cusack, what do you observe from this photo of the knife block?
The main thing I noticed from this knife block is the missing knife is where the large chef knife should go.
And why is that significant?
The missing knife is the same size as the knife that was retrieved from the Brackman's body as the murder weapon.
Objection, speculation. The witness does not know for a fact if the knife missing is the exact same length as the murder weapon.
Mr.
Yes, Your
Hudson?
Honor. This is not being offered for the truth of the matter asserted, but rather the investigator is explaining her opinion, her expert opinion on the matter as to why the knife block was significant in her own investigation about this case.
The objection is sustained. You want to proceed?
Yes, please, Your Honor. Investigator Cusack, was the knife, was the knife used as the murder weapon, was the knife used as the murder weapon the same brand as the other knives in this block?
No, it was not.
Does this affect your conclusions about what happened?
No, it does not, because during my reconstruction process, I noticed that there was a knife drawer opened with a bunch of mismatched knives. It is clear that Mr. Brackman had a bunch of different brands of knives, so it does not affect my conclusion of this case at all, that the knife was from this house.
What information did you gather from examining all of the evidence in this case?
On March 6, 2020, a perpetrator matching the general height and build of the defendant approached the victim's residence with prior knowledge of the property. The perpetrator did not leave as much physical evidence as I would like them to, but they never do. But what I do know is that the scuff marks on the floor, the broken plate, a video surveillance footage, and more, which all indicate Mr. Brackman was in fact alerted of the intruder's presence by the video surveillance footage notification. Then Mr. Brackman proceeded to grab a knife from the knife block as indicated by Exhibit 8. The two began in physical altercation as demonstrated by the broken plate and the scuff marks.
Objection, narrative answer.
Your response?
Your Honor, my witness is proposing a theory in this case, and as an expert is elaborating as much as she deems necessary.
Is narrative your objection, counsel?
Yes, Your Honor. Or sorry.
Overruled.
Yes.
Overruled.
Thank you, Your Honor.
Witness may proceed.
Would you like me to start over?
Nope.
Please
That's
continue
up to
with where you
council,
were.
sorry.
Sorry.
Whichever you feel more comfortable with, Investigator Kuzak.
I'll just go from where I left off. So the two began in physical altercation with the intruder gaining possession over the knife, then stabbing Mr. Backman, fleeing the scene and leaving him to die.
Investigator Kuzak, did you look into any other possible theories of what could have happened in this case?
Yes, I did.
And what are they?
I looked into the Blake Van Owens theory that Mr. Backman was stabbed while he was seated at the kitchen table.
Do you agree with this theory?
No, I do not.
Why is that?
Blake Van Owens' theory indicates that Mr. Backman was surprised by the intruder's presence. I disregarded this theory for two reasons. First being that ring security cameras come equipped with motion detectors that send alerts to the homeowner's phone when motion is detected. And second being, Mr. Backman would have been alerted by the intruder's presence when opening the back glass sliding door. I mean, we all saw Exhibit 12. The glass sliding door makes a considerable amount of noise. Also, Blake Van Owens' theory does not account for the scuff marks on the floor and the broken plate. Frankly, Blake Van Owens' theory is laughably flawed.
Did you investigate and reconstruct this case to the best of your ability?
Yes, I did.
And do you believe your investigation was successful?
I do. The evidence compiled to the sequences of events that I testified to in court today.
No further questions.
Okay, you've just frozen a bit. Did you say no further questions?
I did, Your Honor.
Okay. All right, Ms. O'Connell.
Thank you, Your Honor. Ms. Kuzak, in your statement, you assert that no fingerprints or DNA were recovered from the gate or the back door, correct?
That is correct, because the perpetrator was wearing gloves.
However, you weren't the first crime scene personnel at the scene of the homicide, were you?
I was not.
Isn't it true that multiple members of the crime lab visited the scene before you?
That is correct.
And in fact, those other crime lab members actually processed the scene before you arrived?
That is correct.
Reconstructing a crime scene is a fairly involved endeavor, correct?
That is correct.
It typically involves such tasks as reviewing photographs of the scene, reviewing fingerprints, reviewing DNA, right?
Yes, it is also involved with a bunch of other stuff.
You would agree that after a crime scene is processed, the scene is typically altered to some extent, correct?
That is correct.
So in other words, the scene doesn't look exactly the same as it did when the crime occurred, correct?
Correct.
So you're only viewing the scene and reconstructing it based on the evidence
Objection,
given to
Your
you?
Honor, argumentative.
Okay. Counsel, if you would please wait until she's finished her question before you object.
My apologies, Your Honor.
That's okay. Go ahead, Ms. O'Connell, and Detective, please wait for the objection before you respond. Go ahead, Ms. O'Connell.
Should I repeat the same question, Your Honor?
Yes, ma'am.
So you are only viewing the scene and reconstructing it based off of the evidence given to you?
Objection, Your Honor, argumentative.
Overruled. The witness shall answer.
That is correct.
And in fact, you were not even able to recreate all of the event segments or place all the evidence at the scene, according to your statement in lines 130 and 131.
That is correct.
Let the record show that the witness is expected to be viewing a clean and unmarked copy of what was previously marked as Exhibit 18. Do you have this exhibit in front of you?
Yes, I do.
And did you review this photograph as part of your analysis for the prosecution?
Well, I'm sorry. Would you wait till I get to that? Sorry.
Sorry, I apologize.
You're totally fine. What exhibit did you say?
Exhibit 18, it is of the scuff marks, if you can see.
I'm so sorry. I am having a hard time finding it. Are you able to screen share?
I'm not able to screen share at the moment, but if you can see right here, it is of the scuff marks. Is that clear?
Yes.
I apologize. Can you please tell the jury what this photograph depicts?
This photograph is a photograph of scarf marks that are supposedly of when Mr. Backman and the intruder were in physical altercation.
Your Honor, I'd like to offer Exhibit 18 into evidence.
Any objection to 18?
No objection, Your Honor.
All right, 18's admitted.
Ms. Kuzak, you claim that the scuff marks present on the floor are there because of a struggle,
That is correct.
and scuff marks can be a pretty important piece of evidence in a crime scene, right?
That is very correct.
However, you didn't date these scuff marks?
Correct.
You didn't further analyze them?
That is correct.
So in fact, you really don't have any idea when those scuff marks were created, do you?
No, I do not.
Ms. Kuzak, during the course of your investigation, you determined that the empty slot in the knife block from the victim's home was for a large chef knife, correct?
Correct.
As a result, you conclude that the knife recovered from the body must have come from the knife block, correct?
Correct.
You do not know that for a fact, do you?
No, I do not, but that was my theory.
I am now, or let the record reflect that that the witness should be expected to be reviewing a clean and unmarked copy of Exhibits 5, 6, 7, and 8. Do you have those present in front of you?
Yes, I do.
And do you recognize these photographs?
Yes, I do.
And you reviewed these photographs as part of your analysis for the prosecution?
Yes.
Can you please tell the jury what these photographs depict?
The photographs are the knife pulled out of Mr. Brackman's body as the murder weapon, and you said exhibit 7, right?
5, 6, 7, and 8.
Okay. And exhibit 7 is the open knife drawer full of mismatched knives, and exhibit 8 is the knife block.
Your Honor, I would like to offer Exhibit 5, 6, 7, and 8 into evidence.
Any objection?
No, Your Honor.
All right. 5, 6, and 7 are admitted. I believe 8 is already in.
Oh, I apologize, Your Honor.
That's okay.
Directing your attention to Exhibit 5, Ms. Kuzak, this is the murder weapon, correct?
That is correct.
And you'll note that the logo on the blade of the knife appears to say Chicago Cutlery, correct?
Correct.
And the handle of the knife is a solid silver handle?
Correct.
And then Exhibit 8 then confirms that that knife's handle is solid silver, correct?
That is correct.
Directing your attention to Exhibit 8, this is the knife block you contend the murder weapon came from?
Yep.
None of the handles of the knives in the knife block are solid silver, are they?
No, but as I said in my witness statement, that Mr. Brackman has many mismatched knives, so it doesn't matter that this is a different brand.
Directing your attention to Exhibit 7 is a drawer in the victim's kitchen, correct?
That is correct.
And you'll see that there are multiple knives in the drawer. Would you agree that 3 of those knives appear to have handles similar to those in the knife block?
That is correct.
Ms. Kuzak, in your statement, you frequently refer to blood droplets, blood spray, and cast-off, correct?
That is correct.
You would agree that blood evidence can often be critical in a homicide case?
Correct.
Without the benefit of that evidence, conclusively determining what occurred at the crime scene and the person responsible for the crime can often be more difficult.
Sorry, can you repeat that question?
Without the benefit of that evidence, conclusively determining what occurred at the crime scene and the person responsible for the crime is often more difficult.
Yes, that is correct.
You're aware of the blood evidence in this case because you had an opportunity to review photographs of it, right?
That is correct.
And those photographs are an important component in this case, aren't they?
Yes, they are, but they were lost.
So despite the fact that those photographs are an important component to this case, the jury will never have the benefit of reviewing those photographs like you did?
That is very correct.
Ms. Kuzak, during the course of your investigation, you heavily studied the presence of an intruder through the Ring doorbell.
Yes, I did.
You therefore concluded that the Ring doorbell notified the victim and went to the front door to look?
Yes.
You don't know if the victim's cell phone was turned on during the murder?
Objection, argumentative.
Overruled.
You don't know if the cell phone was turned on during the murder?
No, I do not.
You don't know if the victim had the Ring app on his phone?
The victim must have had the Ring app on his phone because he had Ring security cameras all around his house.
You didn't further study the victim's cell phone?
No.
You didn't know if the victim's ringer was on?
No, I do not know that.
So in other words, you have no idea if the victim even had the Ring alert or let alone heard it?
That is correct.
Ms. Kuzak, you have viewed all the videos and photographs present in this case, correct?
That is correct.
And you have concluded, because of that evidence, that the suspect is Avery Becker?
Yes.
You didn't look at any other suspects who fit the general height and build of the defendant as shown on the surveillance footage?
That is correct.
Let the record reflect that the witness should be expected to be viewing a clean and unmarked copy of Exhibit 17. Do you recognize this photograph, and is it present in front of you?
I'm so sorry, let me get there. Yes, I do.
Okay, and do you recognize this?
Yes.
And can you please explain to the jury what this is?
This is a witness tracking sheet. It helps us keep everything in order.
Your Honor, I'd like to offer Exhibit 17 into evidence.
Any objection to 17?
Yes, Your Honor. I would love to know the relevance of this exhibit submission.
The relevance will be later proved if it is entered into evidence.
Okay, on the basis of that response, the objection sustained.
The Denver PD did not investigate any suspects other than Ms. Becker?
That is correct.
Thank you. That'll be all, Your Honor.
Any redirect of this witness, Mr. Rudson?
Yes, Your Honor.
All right.
Investigator Kuzak, when did the scuff marks on the floor seen in the exhibits take place?
Objection speculation, Your Honor.
So at this point, counsel, you're going to approach and we're going to have a conversation about this. I
apologize, Your Honor.
No, it's okay. No, it's not needed for an apology. So counsel, this is this is redirect.
Yes, Your Honor.
Yes. So the witness previously testified regarding this issue, and the jury will remember the testimony.
Yes, Your Honor.
Okay. So the objection is overruled on that basis. Go ahead, counsel.
Investigator Kuzak, do you specialize in cell phones?
Yes. No, sorry, misspoke.
No further questions, Your Honor.
Based solely on the redirect, Ms. O'Connell, any further questions for this witness?
No, Your Honor, not at this time.
All right. Detective, you're excused. The people's next witness, please.
Your Honor, at this time, the prosecution would like to call Miss Alex Cifuentes to the stand.
Ms. Fuentes, I'll remind you, you're still under oath.
Miss Cifuentes, can you please state and spell your name for the court?
Alex Cifuentes, Sifuentes.
What is your occupation?
I'm a senior at Colorado High School.
Did you know the defendant?
Yes, we were good friends.
Do you see the defendant here today?
Yes.
Your Honor, can the prosecution request that the defendant turn on her camera for identification?
You may.
Can Miss Avery Becker, thank you. Is this Avery Becker?
Yes, it is.
Okay, thank you, Miss Becker. Did you know
You
the
can
victim?
turn your camera back off. Go ahead, counsel.
Did you know the victim, Mr. Brackman?
Yes, he was my mock trial coach for 3 years at Colorado High School.
Ms. Fuentes, I want you to go back to when you said you were a student at Colorado High School. Did you also know a student who went to Colorado High School named Blair Rollins?
I knew that Blair went to Colorado High School, but I did not know Blair personally.
Did you witness any interaction between the defendant and Mr. Brackman?
Yes, Avery and Mr. Brackman often argued with each other.
What was the relationship like between Mr. Brackman and the defendant?
Yes, so
Objection. Objection,
Okay.
Your Honor, lack of personal knowledge.
So
defendant,
that, go ahead, Ms. Entner.
thank you, Your Honor. The defendant was able to see what the relationship between Mr. Brackman and the defendant was like, plus Ms. Cifuentes was the defendant's best friend.
Okay, so there's the objection is overruled as it relates to the basis for the objection, but as to lack of foundation, it's sustained. So, Ms. Entner, if you can lay further foundation, please.
During your mock trial practices, were you able to see the relationship between Mr. Brackman and the defendant?
yes.
What was the relationship like?
Yes, Avery would always come in late, and after Avery came in late for I don't know what, Brackman decided to demote her to B team. But somehow Avery convinced her second best friend, Taylor Perkins, and she got back up on A team. But eventually Avery got permanently kicked off the team for good.
Were you there the day the defendant was kicked off the team?
Yes.
Can you please tell us more about that day?
Yeah, so Brackman was mad that Avery went off script during regionals, and Avery was mad, and so she stormed off and she wrote "Where's Attorney Ward" on Mr. Brackman's car.
Did you interact with the defendant at all after the defendant was kicked off the team?
Avery sent me text messages asking to ask Brackman to see if she could get back on the team.
Do you have a copy of exhibit number 14, Ms. Cifuentes?
Yes, just a second.
Do opposing counsel and court have a copy of exhibit number 14?
Yes.
Yes.
Okay. Ms. Cifuentes, can you please identify this?
Yes, these are the text messages that Avery and I communicated with each other.
Would you say that these are a fair and accurate representation that you and the defendant sent to each other?
Yes.
Your Honor, at this time, I move for the admission of exhibit number 14.
Any objection?
No objection, Your Honor.
14's admitted.
Your Honor, at this time, can I please have permission to screen share exhibit number 14? Thank you. Okay. Can everybody see my screen?
Yes.
Okay. Ms. Cifuentes, what did the defendant say in the text messages?
The defendant said that she was gonna wait until he's at work and then break in and trash his house.
Okay, let's turn back to the day before Mr. Brackman was murdered. Did you interact with the defendant at all the day before Mr. Brackman was murdered?
Yes, I saw Avery at the Fry Shack after a mock meeting, and we talked, and I told her how sorry I was that she got kicked off the team, and she said that I deserved to get the Best Attorney Award. And
Objection, hearsay.
Your response?
What part of it was hearsay?
Your Honor, the witness was testifying to what someone else said who cannot testify as to what they said, or did not testify as to what they said that day.
Can my witness continue without explaining further about what Ms. Becker said?
Okay, so the objection sustained. Yes, you can ask your witness other questions.
Okay. Ms. Cifuentes, did you do anything else with the defendant that day?
Yes, I saw her at the Fry Shack, like I said, and everyone was trying this new trendy game on her phone, so I played the game on her phone.
Did you do anything else on the defendant's phone besides play games?
No, I did not.
So you did not send any text messages on the defendant's phone?
No, I did not.
No further questions at this time, Your Honor.
All right, cross-examination.
Yes, Your Honor. Ms. Fuentes, you think you're quite the devoted mock trial member, correct?
Yes, the day Brackman sent out the openings and closings, I would go home and practice them.
Awesome. Yes or no answers will suffice for this. Thank you so much. And you believe that you're good friends with Mr. Becker, correct?
Yes.
And when you find yourself putting in a lot of time and effort into something, you feel that you deserve something out of it in return, wouldn't you say?
Yes, that's correct.
So when you see someone else who doesn't put in as much as time and effort, yet is being rewarded with greater roles on the team, would you say that this upsets you?
Objection, Your Honor. This is opinion. This is the witness's opinion.
A response?
Your Honor, I can ask them to read a specific part from their affidavit, but they do state in their affidavit that it upset them in multiple different parts of their affidavit that it upset them that they were not being. Would you like me to ask them specific parts of their affidavit?
That would probably be best, and I'm going to strike your prior statement from the record. Go ahead, counsel.
Awesome. Thank you, Your Honor. Mr. Fuentes, could you please read line 29 to 31?
Yes, just a second. Do you want me to read it out loud?
Yes, the sentence starting on line 29 to the end of 31, please.
Okay. I spent so much time honing my craft that it sort of irked me when Avery would just come in and make things up as an examination went along. Avery was just coasting on good looks alone and likely won awards on that basis, not because of any real talent.
Thank you. So to continue, it did upset you that Avery got better roles on the team yet put in less effort than you, correct?
It upset me that mock trial is a team effort, and when Avery wouldn't put in part of the work, it wouldn't help the team grow and be stronger.
Awesome. Thank you so much. And you resented Avery for this, correct?
What is your definition of resented?
Did you feel any hard feeling? I'm sorry, I'll reword. Did you feel any hard feelings towards Avery as a person because of this?
I
Yes
mean,
or no?
Yes.
You did. And you would have liked to seen Avery Becker rightfully or demoted, correct?
No, she was my good friend. I mean, the judges.
But you do believe that you're a better mock trial member than Avery Becker, correct?
Yes, that's correct.
And you were in line to take Avery Becker's position in the event of her removal from the team, correct?
Yes, that's correct.
And the fact that you were a better mock trial member and that you were in line was a part of your desire to see Avery Becker demoted, was it not?
I did not want to see her demoted. I mean, the judges saw potential in Avery and we were good friends. We pushed each other to be better.
Ms. Becker, could you please read 68? I'm sorry, Ms. Fuentes, could you please read lines, the starting sentence on 68 to the end of 69?
Yes. I said I would help, but I also thought the team was better off without Avery, and I was excited for the larger role I would have with Avery gone.
So now that we've established that, just to reiterate, you did want to see Avery demoted from the team, correct?
Yes, that's correct.
Thank you so much. Moving your attention to exhibit number 14, do you have that exhibit in front of you and accessible?
Yes, just a second. Yes.
You do? Awesome, thank you. So regarding these texts, do you have any actual evidence that Avery Becker texted you this before the murder beyond it coming from his contact?
I mean, we communicated these text messages with each other.
But you do not have any actual evidence submitted in this case that it came from Avery Becker himself rather than just his contact.
No.
Okay, thank you so much. No further questions, Your Honor.
Redirect.
Not at this time, Your Honor.
All right. Ms. Cifuentes, you are excused. Thank you, ma'am. Are there any further witnesses for the people?
No, Your Honor.
All right. Is the defense ready to proceed?
Yes, Your Honor.
All right, Ms. O'Connell.
Thank you, Your Honor. I would like to call Professor Blake Van Owen to the stand.
All right,
Professor Van Owen.
Professor, let me just remind you that you're still under oath. All right, go ahead.
Thank you, Your Honor. Professor Van Owen, please state your name and spell the last for the court.
My name is Blake Van Owen, spelled Vanowen.
And where are you currently employed, Professor?
I'm employed at CU Denver.
And what is your job or position there?
I'm currently teaching a course on police practices and social justice.
And how long have you been employed at your current workplace?
For 5 years.
Who were your prior employers?
I used to work at the Aurora Police Department and some others because I've had some other jobs.
And were you subject to any discipline from those prior employers or faced any misconduct?
Yes, at one point I injured a woman of color during an arrest, but I was actually cleared of any wrongdoing.
And what is your educational background, Professor?
I have my bachelor's degree in English from UC Boulder in 2005 and my master's degree in criminal justice from Ashford University online program in 2014.
And Professor Van Owen, what is your rate of pay?
I get paid $225 per hour for any writing, research, or investigation work that I may do, and $450 an hour for any court testimony I may do.
And how many cases have you been retained for?
I've been retained for about 100 cases.
And what types of cases have you been retained for?
I've been accepted in various courts as an expert in crime scene reconstruction, cell tower analysis, and general police investigation tactics.
Have the courts found you previously qualified to be an expert witness?
Yes, in the U.S. District Courts for the districts of Colorado, Kansas, and Arizona, and in state courts in Colorado, Wyoming, Nebraska, and New Mexico.
Is it true that you only testify for the defense?
Yes.
And why is that?
Because prosecution usually uses law enforcement personnel for their expert witnesses, and I can do the exact same thing, but for the defense.
Your Honor, I would like to offer as an expert in police practices and investigations, Blake Van Owen, under Rule 702.
Any voir dire, Ms. Lawson?
Yes, Your Honor.
Go ahead.
In your statement for this case, you included everything that you know of that is relevant to this case, correct?
Correct.
Nowhere in your witness statement do you mention being a certified CSR, do you?
No, I do not.
And the class you teach is about police practice and social justice, correct?
Yes, it is.
And you have a degree in criminal justice?
Yes, I do.
Nowhere in your statement do you mention having a degree in criminology, do you?
No.
Nor do you mention having a degree in any kind of forensic science.
No, I do not.
You only worked at the Aurora Police Department for 9 months, correct?
Yes.
Your Honor, the prosecution objects to Professor Van Owen being entered as an expert in the field of police practices and just police practices.
Any response?
Just to clarify real quick, you're saying that you would only like to enter Professor Van Owen as an expert in police practices, but not investigations?
No, not police practices.
Your Honor, my response to that is that Professor Van Owen here, she has college experience. She teaches about police practices in a classroom. So she has much more knowledge than most people would. And she also has degrees in it as well and was a police officer. Even if it was for only 9 months, she does still know the general practices that the police perform.
All right, I'm going to allow Professor Van Owen as an expert. However, the jury will decide how much credence to give her opinions as it relates to police practices. Thank you, counsel. Ms. O'Connell, you may proceed.
Thank you, Your Honor. Professor Van Owen, what materials were you provided in this case?
I was provided evidence of the murder weapon, pictures of scuff marks by the kitchen door, videos of the intruder from a Ring doorbell, cell tower reports, and some additional screenshots from cell phones.
And were you provided sufficient materials to render your opinion?
I was able to make an opinion on this case, but I do wish that there was more extensive reports from the cell towers and more reliable evidence than just a screenshot.
Did you ask for any materials that were not provided to you?
No, I did not.
And what were you retained to do in this case, Professor?
I've been asked to offer some opinions on behalf of the defense.
Professor Van Owen, in arriving at your conclusions, what specific materials did you rely on?
I relied on the brand of the knife used as the murder weapon, the autopsy for reference of how the knife was held, some Ring videos for reference of the intruder's build and size, and I also used the screenshots and cell tower data.
Let the record reflect that that the witness is expected to be viewing a clean and unmarked copy of what was previously marked as Exhibit 20. Professor Van Owen, do you recognize this?
Yes.
Can you please explain to the jury what this is?
This is my expert report.
Your Honor, I would like to offer Exhibit 20 into evidence.
Any objection, Ms. Lawson?
No, Your Honor.
20 is admitted.
Thank you. Professor Van Owen, I'd like to direct your attention to your first conclusion. Can you please state what that conclusion is?
My conclusion was that I believe that Brockman was caught unawares and stabbed from behind.
And Professor Van Owen, are there any possibilities with regards to the murder weapon that helped you develop this conclusion?
Yes, the murder weapon seen in some of the evidence is of the brand Chicago Cutlery, and the victim's knives in the knife drawer and the knife block are of the brands J.A. Henkel's and Cuisinart, which indicates that the weapon was brought in from outside the home.
And in your opinion, your expert opinion, where was the assailant immediately prior to the stabbing?
I believe that the victim was seated and was taken as surprise by the assailant.
And Professor Van Owen, did you make any determination how the assailant was holding the knife immediately prior to the stabbing?
According to the autopsy, I believe that the knife was held with the blade facing upwards and with the direction of force downwards and towards the aorta with significant pressure.
Thank you. Your Honor, let the record reflect that the witness is expected to be viewing a clean and unmarked copy of what was previously marked as Exhibit 21. Professor Van Owen, do you recognize this photograph?
Yes.
And can you please explain to the jury what this image is?
This is an example of how the knife was held as I previously described.
Your Honor, I would like to offer Exhibit 21 into evidence.
Any objection?
No objection.
21 submitted.
Thank you. And Professor Van Owen, are you aware of the prosecution's theory of the stabbing?
Yes, I'm aware that the prosecution theorizes that the victim was alerted by the Ring notifications and that there was a struggle because of the scuff marks by the kitchen door, and then that the victim was stabbed in a bear hug fashion.
And what is your understanding of that theory?
I understand they believe that there was a struggle because of the Ring alerts, and the scuff marks by the door.
Do you agree that there was a struggle prior to the stabbing?
No.
And why is that?
Because
Okay. Professor Van Owen, you need to stop. There was an objection. Go ahead, Ms. Lawson. What was your objection?
I was objecting to leading for the last question.
All right. Can you repeat the question?
Yes. Do you,
Ms. O'Connell, and then I'll rule on the objection, please.
Do you agree that there was a struggle prior to the stabbing?
Sustained. Ask a different question.
Okay. Professor Van Owen, do you have any theories about a struggle prior to the stabbing?
No, I do not, because I do not believe that there was one.
Now let's turn to the Ring alert. Was that significant to your analysis in this case?
No, it was not.
And why not?
Because there's no official records to prove that the victim had the Ring notifications or even that he saw the alerts.
Professor Van Owen, I would like to turn your attention to your second conclusion made in your expert report. Can you please explain what this conclusion is?
This conclusion is that we cannot be certain that Becker's cell phone was at the residence of the murder, or even that Becker was with her cell phone at the time of the murder.
Are you aware of whether or not the prosecution obtained Ms. Becker's cell phone records from the CDRs from the day before the murder?
No, they did not.
And why is that significant?
Because that would have been pertinent information to this case, because it would have stated if Becker had lost her cell phone, as she says.
Professor Van Noort, I'd like to turn your attention to your third and final conclusion. Can you please explain to the jury what this third and final conclusion is in your expert report?
My conclusion is that the prosecution's safe is not methodologically sound.
And did you arrive at any conclusions or did you arrive at this conclusion based on any evidence?
Yes, because of the cell tower records and the fact that they were not taken from the day before the murder, which would have been very pertinent to this case, and also that they accepted screenshots of a conversation, which is not very reliable evidence, and finally that the Denver Police Department didn't locate Blair Rowlands, which also was a suspect in this case.
Let the record reflect, Your Honor, that the witness should be expected to view a clean and unmarked copy of what was previously marked Exhibit 22. Permission to screen share to play this exhibit.
Any objection?
No, Your Honor.
All right, 22 is admitted. Go ahead, counsel.
Okay. I apologize. Oh, okay. I'm going to play this video for now. If you can't hear it, please let me know.
I cannot hear it.
Okay.
Can't see it or hear it.
All right.
I could hear it a little bit that time, but not very
It
clearly.
was fuzzy.
Okay.
Try one more time.
All right. I apologize. I will try muting myself and see if that does anything. I'll try one more time, and if it is not able to be played, then I will just move on. Was this able to be heard? Okay.
It was unintelligible. Sorry.
Okay. I apologize. Thank you, Your Honor. No further questions.
Ms. Lawson, cross-examination.
Yes, Your Honor. You had an incident during the 9 months that you worked at the Aurora Police Department, correct?
I apologize. Can you please repeat the question? I cannot hear you clearly.
Yeah, you were muddled at the beginning of the question, counsel.
Can you hear me now?
Yes, ma'am.
Yes, much better.
You had an incident during the 9 months you worked at the Aurora Police Department, correct?
Correct.
And this incident led you to leave the APD, correct?
That is correct.
And in your witness statement, you claim to be a check of power of police, correct?
That is correct.
Professor Van Owen, you said that you disagree with the police's investigation methods, correct?
That is true.
In fact, you said that you make a decent living revealing where the police have dropped the ball.
Yes, I did say that.
And you earn a relatively large amount of money for testifying against the police.
Yes, but I do not let the amount of money that I make influence my decision or my investigation.
And you said that you could earn up to $10,000 for this case alone.
Yes, that is true.
And you have only ever testified as a defense witness.
Yes, but that is because I can do the same thing that the prosecution can do.
And you never visited the crime scene, correct?
No, I did not.
And you never interviewed the witnesses, correct?
No, I did not.
And you based all of your conclusions on Markowitz's investigation, correct?
Yes, I did.
And you said that cell towers don't prove location?
They're not incredibly reliable now.
However, you criticized Detective Markowitz for not collecting enough cell tower records.
I criticized that he didn't get them from the day before because that would have been incredibly helpful, yes.
And you also had access to the phone records for the day prior to the murder, but you chose not to access them, correct?
That is true.
Objection, Your Honor. Asked and answered.
Okay. So So you objected after the witness had answered. So are you asking me to strike the answer?
I
Or
apologize.
can we just move on?
I apologize. My mute button did not work. We can just move
Okay.
on.
All right. Let's go forward. Ms. Lawson, please.
And you say that the defendant and Taylor Perkins were trying to locate Avery's phone on the day of the murder, correct?
Correct.
And you also said that Blair Rollins could have stolen the defendant's phone and driven to Mackenzie Brackman's home, correct?
That is true.
And your evidence for this is the cell tower records?
Yes.
And you claim that the messages between Alex Cifuentes and Avery Becker were doctored, correct?
Not necessarily that they're doctored, but they are not reliable piece of evidence.
Do you have access to page 55 of your witness statement?
Yes, I do. Give me 1 minute, please.
And do you recall giving a statement before this trial?
A statement for what?
Do you recall giving a statement for this trial before today?
In my affidavit, yes.
And that statement was made under oath?
Yes, it was.
And you swore to tell the truth?
Yes.
And did you tell the truth?
Yes.
Your Honor, could the witness, do you please turn your attention to line 241?
Yes.
And then will you please read where it starts with the word the?
The problem using a screenshot of a smartphone is that it can be doctored.
Okay, thank you. And you have no evidence to support this claim, correct?
Yes, correct.
No further questions, Your Honor.
All right. Any redirect, Ms. O'Connell?
Yes, Your Honor, very briefly. Professor Van Owen, you have already previously testified that you are paid to speak here today.
That is correct.
And what do you let guide your investigation?
The evidence and only the evidence.
Thank you, Your Honor. That'll be all.
All right. On the basis of that redirect, any other questions for this witness, Ms. Lawson?
Yes, just one question.
All right.
In your witness statement, you say that you propose a theory and you find evidence to support that theory, correct?
That is correct.
So you do not let the evidence guide you?
I let the evidence guide my theory, yes.
No further questions. Thank you.
All right. If the defense wants to call their next witness, please.
Yes, Your Honor. The defense would like to call lay witness Taylor Perkins to the stand.
All right. Ms. Perkins? I'll remind you, ma'am, you're still under oath. Go ahead, counsel.
Thank you so much. Ms. Perkins, could you please state your name, your first and last name, and spell the last for the record?
Taylor Perkins, Perkins.
Ms. Perkins, are you a student?
Yes.
And what school do you currently go to?
I am a freshman at CU Boulder,
And what school did you go to before moving on to college?
Colorado High School.
And were you involved in any extracurriculars at Colorado High School?
Yes, I was involved in mock trial.
And did you have any friends on mock trial?
It was only really Avery.
So let's stop the timing for a second. Mr. Tours, you're having a bit of trouble with an echo. And I don't want the clock ticking against you, but can you try again and see, because it's distracting. Is anyone else hearing that echo? You can shake your head. No, you're not? Okay. All right, let's try again.
I can certainly try again.
Oh, that's better.
Yes. It's better? All right.
Yes, sir.
What we'll try to do is have her muted. But
okay,
just
restart your clock, please. Go ahead.
All right, thank you, Your Honor. So, did you have any friends on mock trial?
Yes, I was friends with Avery Becker.
So, Avery, what was your relationship with him?
We were best friends.
And were you two friends outside of mock trial, or was it just in mock trial?
It was outside of mock trial as well.
And so how would you describe Avery's attitude towards mock trial from what you observed about him?
Objection, Your Honor. This is opinion. The witness is stating what she thinks her friend thought.
Response?
Oh, yes. Your Honor, I'm simply asking, we've already established that they were both on mock trial, that they were friends in mock trial. And so because this was a habitual event for both of them, I'm simply asking her to testify towards Avery's attitude towards mock trial and what she acted like as a member of the team.
So, sustained as it relates to anything she may have said, overruled as it relates to a description of her behavior and interaction in mock trial. Go ahead.
Thank you, Your Honor. So how would you describe Avery's attitude towards mock trial as a generally?
She was a more of a go with the flow type of person, so she generally came unprepared.
And from what you observed, did this attitude create any observable tension within the team?
Yes, this upset Coach Brackman.
And did anything result from this tension between Brackman and Avery?
Yes, one day she was the most unprepared I've ever seen her, and Coach Brackman demoted her down to B team.
And how did your friend Avery respond to this demotion from what you witnessed?
Avery had wrote worst attorney award on the hood of his car, what she thought was permanent or expo marker, but in reality it was permanent marker.
And did Avery ever explicitly explain to you why he wrote that in permanent ink on Brackman's car?
She expressed to me that night that she thought it was expo marker. Avery would never intentionally vandalize someone's car with a permanent marker.
And how did Avery respond after Brackman confronted him on it from what you observed?
I'm sorry, can you repeat the question?
Sorry, so did Mr. Brackman ever confront Avery about this incident?
Yes, and he kicked her off the team.
And how did Avery respond to this?
Avery texted everyone on the mock trial team and went into one of the practices to try and see what she could do to get back onto the team.
And how did you react to this?
I gave her my role.
Why did you let Avery have your role?
Well, to be blunt, Avery is better at mock trial than I am, and I thought she was more valuable to the team than I was, and I felt like giving her the role was the most practical option.
So you did this solely in the interests of the team?
Yes.
So who was in line to be Avery's replacement in the event of their removal?
Alex Cifuentes.
Who is Alex to you?
He's just another team member to me.
However, did you regularly make contact with Alex Cifuentes during mock trial and related events?
Maybe in mock trial once in a while, but outside, no.
So would you say that as close friends of Avery, you had pretty good insight into who his friends were?
Yes.
And did you ever observe him to be very good friends with Alex?
No, I didn't.
So from what you saw of their relations and observed, do you believe that Avery would ever confide in Alex before doing something important?
I do not.
So from what you observed, do you believe that Alex would have a reason to want to see Avery kicked off the team?
Well, yes. Alex was a very dedicated mock trial member and was jealous that Avery got better rules than he did.
So referring to the night that was previously mentioned at the Fry Shack, did you encounter anyone in particular?
Yes, I saw Alex and the rest of the mock trial team.
And how exactly did that encounter go?
We were eating with Alex at the table and we were starting some conversation, and Alex had upset Avery, so she went to the bathroom and left her phone on the table, and then she came back and we left.
And did you notice anything strange or unusual in that night or the next few days?
Yes, I noticed that she was not responding to my text about the next morning about riding to school together.
And was that the last time you saw the phone?
The last time I saw the phone was at the table with Alex Cifuentes.
So what happened the day after your encounter at Fry Shack?
Avery had not answered my text, and she had picked me up that morning, and we had decided to ditch school and look for her phone.
So you spent the day of Mr. Brackman's murder with Avery searching for the phone?
Yes.
So after you left the diner and during the day of Mr. Brackman's murder, did Avery have any phone in his possession?
Not that I saw, no.
Awesome. No further questions. Thank you so much.
Cross-examination?
Yes, Your Honor, thank you. Ms. Perkins, you and the defendant weren't fans of Mr. Brackman, correct?
No, we didn't like the way he coached.
In fact, the defendant was furious with Mr. Brackman, correct?
Yes, that's correct.
The defendant had previously damaged Mr. Brackman's vehicle in a fit of rage, correct?
Yes, but she did not intentionally try to vandalize his car.
Okay. You also claimed that the defendant texted Alex to try to get back on the team. Is this correct?
Yes.
And you and the defendant did not like Alex, correct?
Objection. Speculation.
Overruled. The witness can answer.
Can you repeat the question, please?
Yes, I can. You and the defendant did not like Alex, correct?
Yes, that's correct.
You were good friends with the defendant, correct?
Yes, we were best friends.
Would you say that you would do anything for your best friend, the defendant?
In moral standards, I would not go beyond, but in a general matter, yes.
Did you do mock trial to be with your friend, even though you stated you would rather be doing something else?
Yes, I guess that's correct.
Did you step down from the A team to be with the defendant?
Yes.
Did you skip school to help the defendant?
Yes.
So you have given up a lot of important things for the defendant, haven't you?
That is correct.
So you have done a lot of things that were against your self-interest and even wrong for the defendant, correct?
Objection. Narrative.
Overruled.
Would you like me to
Witness can answer.
Yes, can you repeat it?
Yes. You have done a lot of things that are against your self-interest and even wrong for the defendant, correct?
Correct.
No further questions at this time, Your Honor.
All right. Any redirect, counsel? You're muted.
Yes, Your Honor. I would like to
ahead,
offer
sir.
a redirect. All right. Is everyone ready?
Yeah.
Ms. Perkins, you said that on a moral basis, you would not do anything for Mr. Fuentes, correct?
Correct.
I'm sorry, for Mr. Becker. And do you believe that that this moral standpoint supersedes anything, any friendships or any ties you feel that you have with Mr. Becker?
Yes.
And you were only friends with Mr. Becker, correct?
Correct.
Oh, no further questions, Your Honor.
Any recross?
Not at this time, Your Honor.
All right. Ms. Perkins, you can step down. Defense, call your next witness, please.
All right. Thank you so much for being here today, Ms. Becker. I understand how hard this can be for you. Can you please state your name and spell your last name for the court?
Avery Becker, Becker.
Can you tell us why you're here today, Ms. Becker?
I'm here for a crime I didn't commit.
How old are you?
I apologize. I'm 18.
What school did you attend?
I attended CHS, or Colorado High School.
What year were you in school at CHS last year?
I was a senior.
Did you participate in any clubs after school?
Yes, mock trial.
Did you win any awards for your work in mock trial?
Yes, a few actually.
What was the name of the most recent award you received?
I believe it was Best Attorney Award at regionals.
How did the other members openly react towards you about that?
They were a little upset that I won the award.
Who was your advisor in mock trial?
Coach Mackenzie Brackman.
And what was your relationship with Mackenzie Brackman?
We didn't exactly get along. He would be upset whenever I was a little late to practice or came unprepared. However, he did really care about the team, and he always found a way to get us on top and got us to a place where we were competitive.
All right, so who else participated in mock trial with you?
Taylor Perkins, Alex Cifuentes, and a few other kids from CHS.
Okay, tell me more about them. Starting with Taylor Perkins, how are you related to her?
She's my best friend.
Did you know Perkins outside of mock trial or just in mock trial?
We would hang out often outside of mock trial.
Did Perkins leave the team for you?
Yes. I didn't ask her to or anything, but she said that she didn't really like mock trial that much, and the A team would never win without me, so she quit so I could get back on.
So just to clarify, Perkins willingly left the team for you?
Objection asked and answered.
I was just clarifying if Perkins willingly left the team. Becker had previously stated that she simply left the team, but I just asked a clarifying question. It was not the same question.
Okay, so I'm going to strike the commentary from counsel and sustain the objection. Go ahead, counsel.
All right. What had happened for Perkins to leave the team for you?
I was demoted to the B team.
A while after, why did you get kicked off mock trial?
I stupidly wrote on Coach Brackman's car with permanent marker, which I promise I thought was just dry erase.
Was using permanent marker intentional?
No, I would never do anything intentional to hurt Brackman or his property.
Did you ever try to apologize to Brackman after this incident?
Yeah, multiple times. I tried texting him. I even went to his workplace, but he didn't want to speak to me, which is understandable. But I'm just sorry that I didn't get to apologize to him before he died, and I'm even more sorry that I wrote on his car to begin with.
Thank you, Ms. Becker. Moving on to Alex Cifuentes. Could you start by explaining what your relationship with Cifuentes was like?
We're not friends. I don't know why she keeps saying that we are or that we're close, because we're not.
Would you ever ask Cifuentes for help?
No.
All right, Ms. Becker. How did Cifuentes openly react to you receiving the award?
Well, I know that she's always wanted those awards, so she was upset that I got them over her.
After you got kicked off the mock trial team, who would have been next in line to replace you?
I believe it would have been Alex.
Interesting. Did Cifuentes have any friends that you knew of?
Him and Blair Rollins were close.
What was your relationship with Blair Rollins?
Objection, improper.
Okay, hang on. What was your relationship to Blair Rollins was the question, is that correct?
Yes, Your Honor.
Okay, what was the objection?
My apologies, Your Honor, I misheard the question.
Okay, go ahead, counsel. Thank you.
All right, I'll repeat the question for you, Ms. Becker. What was your relationship with Blair Rollins?
We didn't really talk, but I know her father got sent to jail due to a case that Brackman lost. So I could see how she'd be a little, have some resentment towards him.
All right, let the record reflect that it is expected that the witness is looking at a clean and unmarked copy of what has been previously marked as exhibit number 22. Do you recognize this exhibit?
I do. It is a video of Mr. Rollins' court proceedings.
All right, at this time, we would like to admit exhibit 22 into evidence.
And I think 22 is already admitted, so no problem. Go ahead.
All right, thank you, Your Honor. Was Rollins at school the day after Brackman's murder?
I don't know because I wasn't at school, but she disappeared after he died.
Do you have a copy of exhibits 10, 11, 12, and 13 with you?
I do.
Do you recognize these videos?
Yes, my lawyer showed them to me.
In these ring videos, could you see any specific features that could have identified anyone?
No, aside from the body type looking like mine and Blair Rollins, the person's hands and face are covered.
Improper lay opinion.
I couldn't
Okay.
hear that. Could you please repeat that, please?
Improper lay opinion.
I'm asking
Okay.
her to look at, oh, sorry, Your Honor. Were you?
You're objecting to the response from the witness?
Yes, Your
Miss-
Honor.
Okay. Overruled. Go ahead, Ms. Gouda.
All right. Thank you, Ms. Becker. Now, where were you the day before Brackman's murder on March 5th, 2020?
I went to Fry Shack after school.
Who did you happen to be with?
I was with Taylor Perkins.
Did you happen to see anyone else at the Fry Shack?
Yeah, I saw Alex and the rest of the mock trial team.
What were you and Taylor doing at Fry Shack?
We were just playing on our phones.
Did anyone else play on your phone?
Yes.
Who was it?
Alex Cifuentes.
And what happened to your phone after Cifuentes had it?
I noticed the next day on March 6th that it was missing.
All right, interesting. When you lost your phone, how did you and Taylor try and find it?
We skipped school on March 6th to go look for it. We went back to the Fry Shack. We tried tracking it, couldn't be tracked. We tried calling it, nobody picked up.
How many times did you try and call your phone?
3.
So just to clarify, you lost your phone on March 5th, 2020?
Yes.
What rules did your mom also have for your phone?
I was not allowed to use my phone before dinner unless all my homework was done. However, mock trial was the only exception.
Right after you went to the Fry Shack with Perkins, where did you go?
I went home.
So even if you hadn't lost your phone, you wouldn't have been able to use it?
Yes, that's correct.
All right, Ms. Becker, I have one final question for you. Did you kill Mr. Mackenzie Brackman?
No, the only thing I did, I wrote on his car, and I really, really shouldn't have done that, and I'm sorry.
All right, thank you, Ms. Becker. No further questions, Your Honor.
Cross-examination.
Yes, Your Honor. Thank you. My apologies. Just one moment.
Okay.
Ms. Becker, you were a member of the Colorado High School mock trial team for all 4 years of high school. Is this correct?
It is.
You and Coach Brackman would argue at almost every practice. Is this correct?
I suppose, yes.
And you would commonly say things to Mr. Brackman like, quote, I would tell him that he wouldn't know a good cross if it hit him over the head. Correct?
Correct.
And Coach Brackman often questioned your work ethic?
He did.
He would commonly refer to you as lazy.
Yes.
And as a result of your work ethic, Brackman demoted you to the B team, correct?
Correct.
Taylor Perkins then suddenly quit so that Brackman was given no other option than to put you back on A team, correct?
I guess.
And shortly after rejoining the A team, you and Mr. Brackman had another big fight, correct?
Correct.
And this fight ended with you vandalizing Mr. Brackman's car and writing, quote, worst attorney award across the hood in black permanent marker, correct?
I was upset and acted irrationally.
And Brackman kicked you off the mock trial team as a result of this.
Yes.
And in a conversation with your mother after you were removed from the team, you told her that you would get back at Brackman if it was the last thing you ever did, correct?
Yes, I was upset and I said a lot of things that I didn't mean.
Miss Becker, do you have a cell phone?
I had to get a new one after March 6th, but yes.
When you had your previous phone, your parents were fairly restrictive about when you could use it, weren't they?
Yes.
And one of the reasons you claim to enjoy mock trials so much is because you and Taylor Perkins could text each other from across the room on your phones. Isn't this correct?
It is.
Would you agree that like most other teenagers, your phone is important to you?
Yes.
However, on the day of Brackman's murder, your phone The day before Brackman's murder, your phone conveniently disappeared. Is this correct?
It did disappear, yes.
No further questions at this time, Your Honor.
All right. Any redirect?
Yes, Your Honor. I just have a few questions for you, Ms. Becker. Did you know that you picked up a permanent marker when you went to go write on Brackman's car?
No, I thought it was dry erase.
And also, after you made some irrational decisions and said irrational things to your mom, did you try and go apologize to Brackman?
Yes, I did multiple times.
So you were truly sorry for what you had done?
Yes, still am.
All right. No further questions, Your Honor.
All right. Any further cross?
No, thank you, Your Honor.
All right. The witness is excused. I'm guessing it is time for closing statements. All right. I need to see who's doing the closing for the people.
I am, Your Honor.
Oh, sorry. Go ahead.
Thank you, Your Honor. Your Honor, ladies and gentlemen of the jury, today you've heard the story of a young girl who made a bad decision. Today, the prosecution has shown you three things. First, the crime scene evidence points to the defendant. Second, the crime scene and other evidence was analyzed by two expert witnesses in this case. And third, the defendant had a strong motive. Our witnesses have testified to a complex analysis and examination of all evidence in this case. Our expert crime scene reconstruction investigator, Kyle Kuzak, utilized this evidence to reconstruct the crime scene. She used this evidence to from Detective Markowitz concluded.
You're breaking up.
I'm sorry. Oh, my apologies, Your Honor. Can you hear me better now?
Yes, sir.
Would you like me to restart, or where was the last thing that you heard?
It's up to you, counsel, wherever you want to start again. Sorry.
No, you are totally fine. Thank you, Your Honor. Today, our witnesses have testified to a complex analysis and examination of any and all evidence in this case. Our expert crime scene reconstruction investigator, Kyle Kuzak, utilized this evidence to reconstruct the crime scene. She used this evidence to form theories and, with assistance from Detective Markowitz, concluded all evidence examined points to the defendant having committed these horrible crimes. Today, we learned of a complicated and unstable relationship between the defendant and her mock trial coach, Mr. Brackman. This relationship was so toxic, the defendant went so far as to vandalize Mr. Brackman's prized possession vehicle and write Worst Attorney Award across the hood of his car in permanent marker. Ladies and gentlemen of the jury, let me remind you there are 6 requirements to convict someone of second-degree burglary. Those requirements are as follows: that the defendant in the state of Colorado, at or about the date and place charged, knowingly broke an entrance into, entered unlawfully in, or remained unlawfully after a lawful or unlawful entry in a dwelling with intent to commit therein the crime of criminal mischief against another person or property. Throughout the trial proceedings today, Alex Cifuentes identified Avery Becker as this defendant. Our expert witnesses, Detective Jordan Markowitz and Investigator Kuzak, walked the court through the events that transpired at the Brackman residence on March 6, 2020. You have heard about texts that were sent directly from Avery Becker explaining her intent to break into the home, and saw ring security footage that shows someone of the similar shape and size of the defendant unlawfully entering into the Brackman residence. Similarly, there are 6 requirements to convict the defendant of murder in first degree. It is required that the prosecution has proved to you that the defendant in the state of Colorado, at or about the date and place charged, acting alone or with one or more persons, committed or attempted to commit second-degree burglary. In the course of or in furtherance of the crime of second-degree burglary, that the defendant was committing or attempting to commit, or in the immediate flight therefrom, the death of a person or other than one of the participants was caused by anyone. Our expert witnesses and investigators have shown you Avery Becker's motive, texts that explain her plan to break into the Brackman's home, a quote from the defendant's very own witness statement that said she would get back at Brackman if it was the last thing she ever did. You saw the security footage of the defendant breaking in, and now you see her in court today. Ladies and gentlemen, the prosecution has proven beyond a reasonable doubt that Avery Becker is guilty of these crimes. Now, the justice that the deceased Mr. Brackman receives lies in your hands. Brackman was a mock trial coach with a passion for helping high school students to understand the importance of the law. As a result of his selflessness, he finds himself lying in the morgue. The defendant is a high school student who has received the Best Attorney Award from the Mock Trial Association. She knows the law, yet in a fit of rage, she still chose to break it. Mackenzie Brackman's life was cut short in an act of violence and aggression committed by the defendant. Today, the prosecution asks that you give the defendant the ability to learn from her bad choices. The only way to give the defendant this opportunity is by returning a verdict in favor of the prosecution and finding the defendant Avery Becker guilty of all charges. Thank you, Your Honor.
All right. The closing from the defense.
Thank you, Your Honor. Your Honor, and ladies and gentlemen of the jury, on the evening of March 6th, 2020, Avery Becker was asleep inside her own home while Mackenzie Brackman's family grieved over the loss of their loved one. The murderer should be punished and rightly sentenced, but that person is not Avery Becker. The prosecution has the burden of proof. They are expected to prove, beyond a reasonable doubt, that the defendant is guilty. As you have seen during the course of this trial, the prosecution has failed to meet their burden. The prosecution did not prove that the defendant, Avery Becker, is in fact guilty. The prosecution's witnesses, such as Detective Markowitz and Kyle Kuzak, referenced photographs of alleged blood drops on the floor surrounding the kitchen table, the ceilings, and the walls. However, they also mentioned that those photographs have been corrupted and missing. Ladies and gentlemen, if you cannot see these photographs, how can the prosecution base most of its case around them? The defense has offered evidence each of you can see, not corrupted and missing photographs that you'll never have the pleasure of viewing. The prosecution also theorizes that Ms. Becker was in contact with Alex Cifuentes and told her of her plan. It relies on cherry-picked pieces of evidence relating to screenshots off of Cifuentes' phone. Ms. Becker has testified here today that she was never friends with Cifuentes and never considered her a friend. The screenshots were not viewed directly from Cifuentes' phone, but rather sent from Alex herself. Ladies and gentlemen, screenshots can be easily faked and set up to look like something they are not. Unless the phone is in evidence, which it is not in this case, how do we know that this is not a setup from Cifuentes? The prosecution has also set up the idea of the defendant's cell phone and how cell phone towers recorded the call detail records, also known as CDRs. They claimed the phone was in connection with cell phone towers close to Mackenzie Brackman's residence, and that there were repeated calls and texts to the phone from Taylor Perkins. Avery and Taylor have both testified here today that they were together on March 6th, calling and texting the phone to try and find it. No one answered the phone according to the CDRs. Cell phone towers can be inaccurate, but aside from all of that, none of the messages were answered. There are also no CDRs presented from the day before, March 5th, when Ms. Becker testified she lost her phone. Ask yourself why those are not present. That would be a substantial piece of evidence that supports the prosecution's case that Avery had not lost her phone. The CDR showed that Ms. Becker never answered any calls or texts on the day of the murder. Why would Avery not answer her phone if it was not on her person, especially if it was her best friend? If Ms. Becker was the true murderer in her case, her best friend would have certainly known about it. There are also missing cell phone tower records. If the prosecution was confident enough in their case, they would have presented all evidence and would have gone to lengths to access it. But they did not, showing not only their lack of evidence, but their lack of confidence. Regarding Blair Rollins, ask yourself why the Denver Police Department did not investigate him, especially when Ms. Rollins actually had a motive to murder Mackenzie Brackman. Her father was sent to prison because of the victim, and she has since gone MIA. You recall that Ms. Becker has testified here today that she and Rollins have extremely similar body types. If the prosecution had in fact proven its case beyond a reasonable doubt, Ms. Rollins would have been thoroughly investigated and therefore eliminated as a suspect. Ladies and gentlemen, one of the bedrock principles in our country's criminal justice system is that the prosecution must prove its case beyond a reasonable doubt. And the reason for this principle is quite simple. It is to ensure that an innocent person is not imprisoned for a crime he or she did not commit. It is your solemn duty as jurors to ensure this principle is upheld in this case. For the reasons my team and I have described this afternoon, the prosecution has failed to prove, beyond a reasonable doubt, that Ms. Becker is guilty of any sort of crime. Accordingly, your verdict must be not guilty for Ms. Becker. Thank you.
All right. And you, I believe, have reserved your remaining time for closing rebuttal. Whenever you're ready, counsel.
Thank you, Your Honor. Your Honor, ladies and gentlemen of the jury, the defense's argument is based purely on hypotheticals. They criticize the prosecution in this case for not getting enough cell tower data, saying that it is all our investigation is based off of. Yet their own expert witness criticizes cell tower data and claims that it is not a reliable source of evidence. Ms. Becker testifies that she and Cifuentes were not friends, yet she also testified that Cifuentes was playing games on her phone at the Fry Shack with the rest of the mock trial team, which brings me to question how well the defense truly knows their witness, as their own attorneys could not seem to identify her pronouns and gender properly throughout their examinations. Your Honor, ladies and gentlemen of the jury, I would like to finally remind you that you are allowed to have some doubt to convict Ms. Becker, and I urge you to do so.
Thank you. So the team members are welcome to join us while we are waiting until we get notification that the scoring panelists are done. But in the meantime, I just have to say to you guys, wow. Clearly, you guys have spent so much time. And, you know, in this crazy world that we're in right now, with all the challenges of muting and unmuting and fuzzy and everything else, you didn't let it throw you. So great job. Oh my goodness, I can't even imagine how much time you've spent on this. But I will just tell you, you know, I'm not sure if all of you want to go into the practice of law, but the lawyers who were on the Zoom this evening, all of you, to a person, were better at your direct and cross-examination and your opening and closings than many, many, many lawyers I've seen over the 21 years that I've been on the bench. So congratulations for all the hard work you've done. Very, very impressive. To a person, you were all excellent. And I will wait until I get a signal from Ms. Veronica before I notify you of my comments specifically. But really excellent. If anybody, so Veronica, are they allowed to take a very, very brief break and or does everybody need to stay?
I think we need them to stay here. We are very close to being done with our score sheets though. So if you guys are with us.
Cool.
Yeah, our scoring panelists are on top of it today. So give us just a couple more minutes and we should be good to go. I will let you know as quickly as I can.
Okay. Well, the court is going to take a 2-minute recess.
Judge Arkin. I'm getting, I'm just going to confirm right now that all of my score sheets for our courtroom have been received.
Then
so you can go ahead.
We will proceed.
Yes.
Terrific. So I'm going to be very, very fast. And Mr. Routzen, I hope I'm not mispronouncing it yet again. You did an excellent direct. Your closing was terrific. Ms. O'Connell, you made an objection that stopped the other counsel in their tracks. Great job. The direct of Ms. Van Owen Professor Van Owen was fabulous, and your redirect was excellent. You rehabilitated your witness on just the points you needed to. Great job. every single person needs to think about. And so yours truly, when I was practicing law, and at the beginning of every question, you just have to think about it. It's terrible. You read a transcript, and even sometimes as a judge, there would be an and or an in my rulings. It's hard to do that, to get rid of those ands, but pretty much all of you guys. Oh, Ms. Gouda, you did interesting. It was a lovely tactic, but I'm not sure that it would work for a criminal case. Okay. But Ms. Gouda, your opening was very emphatic. It was excellent. I would caution you to be careful about the word innocent. Juries don't find people innocent. They find them not guilty. Just a little bit of a statement there, but your voir dire of a witness was terrific. Ms. Lawson, great impeachment, excellent foundation, direct, better than many attorneys I've seen, many. The expert, Ms. Rosenberg, great detail. Mr. Tours, you did a terrific job of your cross of Cifuentes. I would just tell you that you enjoyed it a little bit too much, so you need to be careful about that. Jurors sometimes will get you if they think you're enjoying yourself too much when you tear your witness to pieces. So you were doing a great job, but be very careful about them not wanting to see you as smarter than the other person. Boy, Ms. Conklin, you have an acting career ahead of you. You definitely need, you were very convincing as the defendant. Let me see, I apologize. See if there's anything else that I didn't, Entner, Ms. Entner, very thorough opening and terrific cross-examination. Those are all my notes, and I'm passing the students to the next commenter, please.
Yes, perfect.
And great job, you guys, really great.
Thank you, Judge Arkin. So scoring panelists, we're going to jump to your feedback now. If we could keep your comments to maybe less than 2 minutes. And Truly, why don't we start with you?
Okay. Hi, everybody. Great job. Students, I am very impressed. I've watched some of the attorneys I've worked with for a long time in court, and you guys definitely rival. You guys have done a great job. You've done your homework. I thought you were all very professional, very clear. I think the only comment that I'd say that needs to be worked on a little bit is the direct eye contact. I think it's really good. I know it's hard because of the video to do that, but especially if you're going to be looking at a witness or the jury during your opening, especially, or closing, that direct eye contact, I think, means a lot to a lot of people, and it's a sign of respect for them as well. So I think that would be very good. I will echo Judge Arkin's comments on watching the ands and ums and things like that, but we are all guilty of that. But other than that, that's great. I honestly thought that everybody did a really good job, and I don't want to pick on anybody or say anything individually, but I just wanted to give some general comments. Thank you.
Mr. Montag?
Perfect.
Well, I want to congratulate all of you. I want to, obviously, like Judge Arkin said, you guys have put in the time and effort to prepare this case, and you did so really well, especially with the adjustment to the virtual court appearance. That's not easy, and I've been in trials virtually recently where people are fumbling far more than you guys are, so well done there. One thing that I noticed is that when you're cross-examining or if you're direct examining a witness and opposing counsel objects, you should allow the judge to give the judge the opportunity to speak, because it's possible the judge could just rule on the objection and then you move forward, or the judge could ask you for a response. And if that occurs, take a deep breath and think about the objection and think about your response. And if you truly want to move on, you can say, I'll just move on, Your Honor. But I think it's always worth giving a response, because you never know what the judge is going to do. And you can just, even if it's not rooted in the rules of evidence, which you should try to do, but if it isn't, then if you just give a response that is logical, the judge could agree with you, and then you get what you want, and then you can continue on with that question. And so if you get an objection, just think about it and try to formulate a response as best you can. And then one other point I wanted to make was that, and this is difficult to, it's similar to the ands and the ums when you're answering or when you're questioning a witness, but when you're cross-examining, you really should try to avoid ending questions with correct or right. And that's because it's kind of inherent that you're asking a question, and if the witness gives you trouble, like, is that a question? You can be like, yes, it's a question, but you don't need to use the correct or the right. And I think every once in a while it's appropriate and it can be beneficial, but try to avoid repeating those corrects and rights when you're cross-examining. But otherwise, you guys did really well. Congrats.
Okay, I think I'm up next. Okay, great. Excellent job, I think, to everybody. I think that it's worth noting that everyone had really great demeanor and really great flow, which is a hard thing to convey over video. You guys didn't necessarily have maybe the terror and or fun of being, in the courtroom, at the lectern, on the witness stand, but I thought everyone did a really great job where they were at to really be personable, which is hard to do over video. For the attorneys who gave opens and closes, I thought those were really well organized. They flowed really well. The prosecution laid out the elements, the defense refuted the evidence. I thought it was a really good job on all 4 attorneys' parts. Both sides were really active with objections. Some of them were risky, but I thought that was good. It's a good effort. And I would echo what Mr. Montag said about, think through what your responses are when you get those. And I thought that oftentimes, even if an objection got sustained, which as the direct attorney, you never want to necessarily happen, but I thought that everybody did a pretty darn good job of kind of gaining back composure and even thinking through. I even saw a couple times that some of the counsel thought through questions that they might have prepared but had gotten objected to, and they were like, oh, you know what, I need to rephrase this. And I thought that was really good. That's thinking on the fly, and that's what you're going to have to do. One note for the attorneys, and I think it's a little bit tied to some of the comments that have been made. I know it's hard over Zoom, but try not to interrupt. Certainly try not to interrupt the judge, but also the witnesses. Even if it's your witness, a lot of times you get stuck because you've prepped that witness. It's your witness. You know what you want to ask them. You know the answers you want to get back. And it's easy to jump to your next question before an answer is already done. So just make sure that you're thinking through that and pausing. And I mean, obviously the same on cross. You don't want to interrupt your witness. You just don't. It doesn't look good. But I think overall it was good. And again, I note that is slightly more difficult to do on Zoom. And then finally, for the witnesses, I thought the witnesses did a great job. You guys were really well prepared. I thought that you answered your attorney's questions well. You answered the cross well. I saw a couple of times on cross witnesses thinking through their answers and saying, yeah, that's correct, or yes, I guess that is true. So I thought that was a really good job, because that shows that you know your stuff, you know your answers, and you know the character that you're playing. So really great job to everybody.
Yeah, that was fantastic. Veronica, are we done? Is everybody?
We are done
Are
for
we?
the night, everyone. So Judge Arkin, thank you for your time. Scoring panelists, thank you as always for volunteering your time for us and supporting the mock trial program. And team members, best of luck throughout the tournament. Get some rest, and we'll see you all tomorrow. So I'm gonna shut down the live stream now and close our courtroom. And good luck, everybody. Thank you. Have a good evening.
Thanks, Veronica. Take care. Thanks for your time also.
Thank you
very much. Thank you.
Take care.
Thank you.